because once we make our designations, they make their counter designations, they object to our designations, and we do our objections to their counter designation. You know, it's a whole little process. We weren't sure if that needed to be done.
All right, let's go ahead and set forth our appearances for the record.
Your Honor, Will Kemp, Theodore Parker, and Eric Pepperman for the Plaintiffs.
Good morning, Your Honor. Jim Neale for UNFI, weighing on local counsel, Mr. Davis.
Morning, Your Honor. Jim Kavanaugh, third party defendant, Will Water, Tennessee.
Okay, who's that?
Good morning, Your Honor.
Okay, go ahead. Mr. Odou.
I'm sorry, Your Honor. Good morning. Joel Odou on behalf of Real Water and Affinity on Blue Jeans.
Good morning, Your Honor. Rob Robbins, Milwaukee Instruments.
Good morning, Mr. Robbins. Anyway, it's my understanding we have a little bit of a snafu as far as everyone understanding the appropriate time to start. Is that correct?
It appears that way.
It appears that way. Anyway, and this is why I came.
Your Honor, I apologize.
Yes.
This is Scott Rasmussen. I just need to make my appearance on behalf of Hanna Instruments, also on Blue Jeans.
I understand. Anyway, here's my point. At 10 o'clock, I have to go down and swear in the remaining panel members. And it's my understanding 1,405 have filled out questionnaires, something like that.
It's a large number, Your Honor.
That's a large number. But my point is this. If we're still waiting on council, we can't get started until they get here. Instead of everybody rushing and being concerned, and I guess it was a misunderstanding, we're starting at 10:30. We just might as well start at 10:30 unless someone has an objection, right?
I don't have any objection.
Yeah, I mean, and so if Mr. Rasmussen wants to come here personally, sir, you have an hour to get here?
I think we'll make it happen.
All
Come pick
right.
me up, Scott.
I will do so, Joe. I'll be right over.
Yeah, but my point is, there's no reason to stress out and all those things. We're here. If there's a miscommunication or whatever, it doesn't matter. We'll start at 10:30. At 10 o'clock, we'll go down and swear in the man.
Thank you.
Okay.
All right.
Thank you, Your Honor.
Thank you, sir.
Thank you.
All right.
Department 16 is now in session. Honorable Timothy Williams presiding. Please be seated.
Okay, we're on the record and everyone's here, right?
Yes, Your Honor, if I may, I apologize to the court for this morning
Oh, that's okay.
for being late.
I understand. Well, there's a little miscommunication. It happens from time to time, right? So anyway, let's go ahead and set forth our appearances for the record.
Your Honor, Will Kemp, Theodore Parker, and Eric Pepperman for the Plaintiffs.
Good morning, Your Honor. Jim Neale and David Spurlock for UNFI.
Good morning, Your Honor. Joel Odou on behalf of Real Water Inc. and Affinity Lifestyles of Real Water Gold Coast.
Morning, Your Honor. Scott Rasmussen on behalf of Hanna Instruments, Inc.
Morning, Your Honor. Jim Kavanaugh for Real Water, Tennessee, LLC.
All right.
Rob Robbins for Milwaukee Instruments.
There you go. I think that covers all appearances. Is that correct? All right. So anyway, I guess we might as well get started. As far as the total number of questionnaires filled out, it'll be 1,423, based upon the final tally. So much. 1,423 have been completed. We're in the process of finalizing them right now. And we had I guess the last batch was probably only about 18 or so. Anyway, you'll get those shortly.
Thank you.
Moving on, I guess, we have a couple matters on. I guess the first matter to deal specifically with would be the Pro-Hot Beach Che application, right?
Yes, sir. Good morning, Your Honor. Joel Odou on behalf of the Real Water entities. This court, I'm sure, is very well aware. Pro-Hot motion is both the pleasure of this court and the pleasure of the Nevada State Bar. In reviewing the objection and the cases cited in the objection, I can certainly speak for quite a few of these. A couple of these were set for the same trial date as this case. In particular, I see the denying case, which is before this court. That trial date was set for the same date as this case. In that particular case, we associated in one of the associates outside of our Las Vegas office to assist because we knew it was set on the same date as this case. In addition, on the list of pro-hocs filed by or petitioned by my partners is the rent case. As this court's well aware, there are a number of consolidated cases. In fact, the Wren case is set for trial right after this case. And in fact, the plaintiffs have actually asked to extend the dates in that case because we can't be in two places at once. Finally, in looking through the list, I see other cases where we had associated in somebody outside the state of Nevada because, again, I personally couldn't be involved in that trial. I see the Rosenstein case as an example. I was supposed to be lead trial counsel in that case, but I would say happily, I was lead trial counsel for this case, and very proud of that fact. Therefore, one of my partners who's admitted to practice in Nevada, I think associated somebody else with him on that case. I also see the Hahn case. The Hahn case actually was my case as well, and it's not our firm that we associated in. The Hahn case involved a claim against Little Caesars Pizza, and Little Caesars corporate counsel wanted to be part of that case so they could monitor the pleadings and attend court hearings, and so they were associated in. Finally, I see two cases that were Legionnaires cases. This court, I'm sure, is very well aware of Legionnaire cases have kind of acquired a notoriety, and there are specific attorneys throughout the country that litigate Legionnaires cases. In this particular instance, some of those attorneys are at my firm and associated in with my partner, Janice Michaels, on the Legionnaire cases. I don't think there should be any doubt that I will be lead trial counsel in this case. The reason why my clients are seeking to associate in this, I'll just say Graham and Karen, was in the event that this case overlaps with other real water cases. Again, as this court's well aware, there are probably 19, 20 real water cases that are coordinated for discovery. The discovery in the Wren case in particular is going to occur simultaneously with this case. As part of this case, my associate, Mr. Kaufman, who was helping me out, became ill, was unable to attend several days of pre-trial hearings. And so on those dates, it was just me. And so I approached my partners about asking for additional help in the case that either, heaven forbid, myself or Mr. Kaufman get ill. But this case will be primarily defended by myself and Mr. Kaufman. Graham and Karen are really back up on this case, and I thought it was important for the court to know that and know the rule and know why we are seeking pro hoc vice applications on behalf of the two of them. And that is for the very simple reason so that this case doesn't get derailed by any type of illness or conflict with any other case, so that we know the jury's time is precious, and I don't intend to miss any of this trial if I can absolutely help it, and I know Mr. Kaufman feels the same way. And for those reasons, and the fact that the Nevada State Bar didn't seem to have an issue with it, we would request that the court exercise its discretion and grant this.
Thank you, sir. Mr. Pepperman.
Thank you, Your Honor. I guess I'll start with the end first. I don't know that any of the attorneys here have a backup trial team. I think, things come up, you don't expect it, and if during trial, and if that were to happen, then we could address those issues at that time to make work what makes the most sense. The 11th hour justification to try to associate in, attorneys who haven't been here the entire time, who clearly don't qualify under the Nevada Supreme Court rules, I don't think is something that should be entertained. But I do want to focus on the rule, which is Nevada Supreme Court Rule 42.6, and it's clear. It doesn't talk about the state bar application. It talks about the motion to associate, which is what we're on. And it says, absent special circumstances, repeated appearances by any person or firm under the rule shall be cause for denying the motion. So to say that the state bar somehow blessed these prior appearances is incorrect, because that rule addresses your discretion on whether to grant or deny the motion to associate, and that's where this is relevant, and that's where we're raising it. For both the attorneys, for Mr. Miller and Ms. Schaefer, their firm of attorneys have repeatedly appeared more than 10 times over the last 3 years. And I note that the application identifies these at least 10 prior pro-hoc appearances, but it omits at least 2. Both the same attorneys appeared in the Wren case, but they only identified 1 prior admission in that case and on their applications. And Mr. Kaufman appeared pro-hoc in this case. That's missing from the list as well. So there's at least a couple more that are on the list that they've appeared under the rule more times than the 10 that are listed. They're admitting out-of-state attorneys from this firm on an average every 3 months over the last 3 years. They provide no good cause for another repeated appearance in this case. The only proper basis in the motion for another admission in this case is for the attorneys to assist with discovery, ancillary discovery, but discovery is done in this case. They're admitted in the Wren case, which is coordinated, in the lead case in the coordinated action, so there's no reason to admit them in this case for assistance with completing discovery in the coordinated action. What we're talking about here is a case where discovery is done, there's no need for assistance with discovery, and we're starting trial in less than 3 weeks. Mr. Odou and Mr. Kaufman are competent attorneys. They've been participating in all the discovery, all the expert depositions. Mr. Odou's been here for all the pretrial hearings over the last month, and we have significant concerns bringing in brand new attorneys who haven't been here on the eve of trial. They haven't been part of these discussions for the past month. They haven't heard your Honor's explanation and your thinking on these issues and the rulings that you've provided and the parameters of the trial. And so it is questionable that they're trying to bring in new attorneys in this case on the eve of trial. We have to question what their involvement is going to be. And while I don't question Mr. Odou's credibility and don't want to say anything of it, there's a reason why they're seeking to bring him in this case. And Mr. Odou can minimize their involvement all he wants, but we don't know. Things change, how things develop, and we have concerns about bringing in brand new attorneys on this case on the eve of trial who don't qualify under the rule. So for all of these reasons, Your Honor, we ask the court to deny the motion to associate. Both motions to associate.
I have just a couple comments that'll probably lead into questions for both of you. And I've taken a look at Nevada Rule of Supreme Court Rule 42, and more specifically 6A, and of course 6C. And I kind of read the rule this way. This is how I interpret it. And 6 talks about the discretion the trial court has, right? And it talks about absent special circumstances, and I get it. And then 6A gives the limitations period. We can agree with that. But then I go to 6C, first and foremost, if I'm going to make, if this is challenged under the facts of this case, I have to make specific factual findings, right? And so that would be the basis for it. But I get the impression this is potentially overlooked because under the final findings of special circumstances under section 6C, it appears to me to be a qualifier there as far as the findings I have to make, because it appears that the rule changes from a finding of special circumstances because the Supreme Court in the rule, when you have requests made that are, and let me see here, in excess of the limitations set forth in 6A, which deals with the more than 5 appearances by any attorney granted under this rule in a 3-year time period, then the analysis changes. And what I mean by that is this: it says, quote, an application's appearance in excess of limitations set forth in paragraph 6A of this rule shall be a rare exception, granted only in truly extraordinary circumstances. And that's what the rule says. And so I think right now, and here's my point, hypothetically, if Mr. Odou during trial was unable to continue, and maybe there was a situation where the, of course, his client would have to have some sort of appearance, I mean, some representation that would be material. Maybe under those circumstances, when Mr. Odou couldn't perform, maybe based on a health circumstance, it would rise to the level of a potential rare exception, right? But I'm looking at it through this lens. It seems to me that whatever decision I make, number one, I have to make findings, but more importantly, an applicant's appearance in excess of the limitations set forth in 6A of this rule shall be a rare exception granted only in truly extraordinary circumstances, period, close quote. That's pretty strong language there as far as, I guess the best way to look at it, that's a limitation on my discretion that I can exercise in this case. And so I'd have to make a specific finding that the admissions would be a rare exception pursuant to the rule. And it would have to be under truly extraordinary circumstances. Now, if I'm reading it wrong, you can tell me. That doesn't bother me if I'm misinterpreting the rule. But that's what it appeared to be to me when I reviewed it.
Your Honor, we completely agree with your interpretation, as stated in our opposition, that the present circumstances do not present the truly extraordinary circumstances in which justification in violation of, or in excess of the number of appearances required under the rule would be allowed. I think your interpretation is exactly right, and it's exactly how we read it.
Okay. Mr. Odou, of course, you get a chance to respond to that, sir. You know that.
Yeah, I think, I think Mr. Pepperman.
Oh, are you? I'm
No,
sorry.
I agree.
Are you done? Okay, sorry.
Because we can all agree that's pretty strong language.
Yes,
It really is.
and we have asked the Nevada State Bar about that language, their interpretation. I understand this court's interpretation is binding. But I think it's helpful to know how the Nevada State Bar treats that, and they treat it as an applicant. In other words, if Ms. Schaefer, as an example, had sought admission before this court multiple times, I think there's an old case on it that comes, probably from the late 90s, early 2000s. I was unable to find it, but I know this has come up in the context of construction defect cases. In fact, I can remember the entity involved was Davey Roofing, and they had an attorney in Southern California who was appearing in construction defect cases numerous times. And eventually, I believe that a state court judge, possibly Judge Earl, had said to the attorney from Davey Roofing, look, you either need to get admitted to practice here or quit showing up in my courtroom. I don't know if that was appealed, so it may have just been a trial court ruling, but I thought that was a reported case. But in talking to the state bar, they'd always interpreted it the same way. And the reason why it came up that way is we had inquired on the Hahn case, which involved, again, a non-lawyer from New York who, I believe Washington, D.C., excuse me, who wanted to be admitted pro hoc vice to assist me with trial in the Hahn case. And that's how that came up. And so we had been told by the Nevada State Bar that it applied to individuals. Now, again, I recognize the language of the statute. I recognize the court's got discretion.
Yeah, well, the only reason I bring that up, and I mean, trust me, I respect the state bar, but the language of the statute says repeated appearances by any person or firm of attorneys.
Yes,
under the rule, that's what it says.
it is what it says, and, the way it was explained to us, you know, granted.
No, I'm not saying you're doing anything wrong, Mr. Odou, I'm not,
Appreciate
I'm not, no, that's not where I'm going on this. It's really just a strict interpretation of the rule, that's what I'm doing.
Yeah,
Nothing more,
again,
nothing less.
We'd actually asked the bar about that, and they had, or the bar is very involved when you file a Pro Hoc application. And we've had numerous discussions with them, to make sure that we get it right. Again, they have.
I'm not saying please understand this, I'm not saying anybody did anything wrong by making the application or any of those types of things. I'm looking at it through this lens. Number one, what does the rule provide, right? And number two, and when I interpret it, and it appears to me, they place a qualifier as to the number of appearances within 3 years. And then what the rule says, and it's pretty clear, it says, quote, an applicant's appearance in excess of the limitations set forth in 6A of this rule shall be a rare exception granted only in truly extraordinary circumstances, period, close quote. And here's my point there. I clearly have to make a finding of facts, because that's required under the rule too, as it pertains to special circumstances. But it appears to me that what the Supreme Court is saying is, look, under the rule, the trial court has discretion. Here's your parameters. But if you have a scenario where hypothetically there's more than 5 appearances by any attorney granted under this rule in a 3-year period in excess of the rule, then I have to go down, and that's where I have to make where it specifically discusses, I guess we could call it a qualifier or what, but and they say shall, meaning mandatory, a rare exception granted only in truly extraordinary circumstances. I don't mind saying it. Before I came out, I was saying to myself, okay, what does it specifically mean? There wasn't necessarily a Black's Law definition I could look to. I did have my law clerk start doing some research on potentially what, and he didn't have really enough time to dig deep, but what truly extraordinary circumstances would be, how that would be defined. But that seems like a very high bar to me.
Yes, for the second prong of the test, it would be a high bar, just to make sure that I'm being clear. I'm talking about the applicant. In this case, the applicant attorney has only been admitted in the Wren case, Ms. Schaefer and Mr. Miller.
Excuse me, Your Honor.
That's okay. That was a dramatic false for my point. Mr. Miller and Ms. Schaefer have only been admitted in the Wren case. And the specific reason why we sought their admission in this case was because the Wren case discovery will be ongoing during this trial. And I could foresee a situation where I might be requested to take a deposition in the Wren case. And of course, I've never asked the court not to impanel the jury on the day because the parties have a deposition in another case. I would not show that discourtesy to the jury. But the fact remains that we're set on really more than a double track in these real water cases. And I will be here every day for trial. Mr. Kaufman will be either online or here every day in person for trial. We are the lead trial team. In terms of backup, I think that's inaccurate to call them backup. It's more of a belt and suspenders to make sure that this trial, if it really does go 3 months, is adequately staffed, regardless of what happens. And so, again, we had interpreted the rule as the applicant, Mr. Miller and Ms. Schaefer, have only been admitted pro hoc. And the reason why that rule makes sense, I might digress for a minute. The reason why that rule makes sense, and what the Nevada Bar had explained to us, is it's put there obviously to protect the reputation of the practice, but it's also put there to allow for the appropriate supervision by Nevada attorneys in cases such as when I had the in-house attorney from a corporation wanting to participate, and certainly that pro hoc shouldn't be accounted against real water. It had nothing to do with real water. In fact, that attorney deferred everything to me and didn't end up appearing in the cases. Some of these other cases are cases where applications were granted and then the case, for whatever reason, either resolved or went away. And again, neither Mr. Miller nor Ms. Schaefer were in any of those cases. And so we would again point out to the court, or request the court to grant this application. It really is a belt and suspenders. We actually thought about withdrawing this motion a couple of days ago because of the fact that it looks like the Wren discovery is not going to be completely overlapped here, but that's still up in the air, and the Wren discovery is probably going to be concurrently occurring with this case. So with that, I'll leave it to the court, and certainly happy to answer any other questions the court has.
Okay, and thank you, sir. This is what I want to do, and as far as the finding of special circumstances, and specifically interpreting Supreme Court Rule 42(6), and it appears to me, when it comes to exercising discretion, the Nevada Supreme Court has focused on, quote, absent special circumstances, repeated appearances by a person or a firm of attorneys under this rule shall be cause for denial of a motion to associate such person, period, close quote. And here's my point, and I do feel, and the rule is what it is, under the facts as it currently sets, as it pertains to what's spent in this specific case, I can't say for now that the request meets the qualifier as it pertains to the time limitations and the number of appearances that's set forth in the rule, where it provides, quote, an applicant's appearance in excess of the limitations set forth in paragraph 6A of this rule shall be, meaning mandatory, a rare exception granted only in truly extraordinary circumstances, period. I don't think we rise to that level. But for the record, I don't mind saying this, Mr. Odou, I'm going to deny it without prejudice, because if something happens that maybe, and we don't know, and you do have counsel listening in, but if something comes up during the course of the trial that can meet that definition where I can make those specific findings, then of course I'll accept the petition with an order shortening time and get it done very quickly.
Appreciate that, Your Honor. Thank you.
Yeah, but I think that's what the rule provides, so I'm gonna deny, it's denied. If there's truly exceptional circumstances that arise, please bring it back.
We will do that. Thank you, Your Honor.
Okay. So, where do we go from here?
Judge, I had one minor point before we start.
Yes, sir.
Can I have that up, please, Chris?
And we can, also maybe before we get started, we'll talk about scheduling too. But go ahead.
I was doing page lines over the weekend because we had filed the page line deposition designations on Monday. And so I reread Mr. Pham's deposition, and I realized that we had not brought one thing to the attention of the court that I thought was very important. And it was that Mr. Pham, this section of testimony is Mr. Pham's deposition. I think this is page 113. 113, Chris?
Yes.
113 lines 11 through 18. And so he was asked whether he's seen the purchase records, and this is Mr. Hoffman asking the question, this is me, that he was actually feeding the dog of the neighbor, who's the neighbor and his wife both were transported by ambulance. So he was feeding the dog, and he personally observed the retail bottles of real water on the counter. Okay, so he actually saw it. He didn't see the receipt. He says that right in the testimony, but he personally saw it. So we have the situation where he personally recommended to them that they go to Whole Foods and buy the water. He personally saw the 2 ambulance trips, and he personally saw the water at the house. So I just want to bring that additional fact to the court's attention because the motion's still under advisement.
I understand.
May I briefly, Your Honor?
Of course.
And of course, what's missing there is any link at all between the reason for the ambulance trips that Mr. Pham observed and the consumption of the water. There's just no link at all. He saw water, he heard his neighbor say that he drank it, he heard his neighbor say he went to the hospital. He had no idea what the injuries were or if there was a relation. And for those reasons, Your Honor, we continue to believe that the Tom Pham testimony is inadmissible on that subject.
And for the record, this is related to which motion, Mr.
That's number 14, Your Honor, UNFI motion was made number 14 to exclude evidence of unrelated customer complaints. The court indicated its ruling on all the other, but wanted to look at the FAM thing. I think the court actually took a copy of the deposition, if I remember right.
I think so.
Yeah, I think it's, and perhaps it touches on 16 as well. We raised the issue there as well.
And here's my, and I guess before we start digging in, as we know, the Ramirez case settled, right? So that gives us a lot more time. And what was that set for, 2 weeks?
That was set for 1.5 weeks.
Well, might as well say 2 weeks. So that pretty much, that opens us up until we start this trial, right? Okay. So from that perspective, we have to do a little planning. And here's my point. And just like lawyers, judges get a little overly optimistic too as to what can happen. And what I mean by that is, since we last met, we've been in trial every day.
Yes.
Remember, I thought I was going to have some downtime. Didn't happen. Literally didn't happen. And I don't know why I thought we were going to have downtime. In fact, it's a breach of lease, covenant of good faith and good dealings case. They're doing closing arguments at 1:15 on Monday, right?
Yes.
And so from this point on, where do we go as far as continuing the scheduling of the motions, right, and setting time aside? I can tell you this, and I thought about it, and I do need, there's some, I do need, a little, because I get a lot done when I have my administrative time, right? And I do have some decisions I want to tweak and publish, right? And so I'm looking at it from this perspective, and does this make sense? For all practical purposes, Monday afternoon's done, right? Because they have closing arguments, and I don't know how long they're going to take. We have Monday morning, and we could use that, but it sure would help me getting things done if I could come in fresh on a Monday morning. And,
Your Honor, Mr. Kemp and I are happy to give you Monday morning.
Yeah,
okay, all right.
In light of this hurricane or
Yeah,
whatever, we thought it'd be a good idea not to schedule something on Monday morning.
well, that's good, because it would really, and that helps everybody out, right?
Right.
Yeah, Charlie, not the hurricane.
Hannah agrees as well.
Oh, yeah.
The water Tennessee agrees.
Oh, yeah, and we have the hurricane coming.
We have a hurricane,
We're
yeah, I don't
not
know if
used to
you're
the
gonna count.
hurricane coming in from the west, right?
Yeah, that's in
Yeah,
To the south.
South, or, yeah, I saw it's coming up,
South.
the Baja Peninsula and all that, right?
Interesting. So we could start Tuesday afternoon, whatever the court has available.
All right, and how are we Tuesday? That works out really good.
Your Honor,
Yes, sir.
Lynn did create a kind of a partial calendar for
You
what's
know what,
available.
and I don't mind saying this, and, I mean, I think I have a great staff, and the reason I say that is, my law clerk was studying for the bar, so I had 2 weeks off, and that kind of takes away from, because I can't type. I write stuff up, I give it to him to type. And then I think Lynn's really good, but she was on a 2-week vacation, you know, and she deserved it. But what does she have? And that's kind of my point. She's very well organized.
Yes, she is, Your Honor. We have a calendar here, if you'd like me to pass it out.
Pass it out.
Kind of, you have a similar one on your desk, Your Honor, or on your bench.
I'm sorry about that. And we're gonna pass it out, hopefully got enough copies,
Let me just.
and that way we can have calendars in front of us, and if there's a problem, we can deal with it. But we try to be organized, and I'm not organized, my staff is really organized. Well, I try to be a little organized, but they're wonderful, I will say that.
Your Honor, Joel Odou on behalf of Real Water, we would also offer the Real Water motion to eliminate 1 through 14 to submit them without oral argument, considering the limited number of days that we have left. So I'll throw that out there, and certainly plaintiffs can consider whether they want to have oral argument on those. But I think a lot of them have been covered by the rulings of this court
Well, I
that we
can-
received.
Yeah, I can say this too. I mean, I have a much different perspective of the nuances of this case today than I did the first week. You know, I kind of get it. I did.
Yeah, Judge, we met on that exact same subject over the weekend, and I have my list of 1 through 14 with good water. We wanted to argue a couple of these, so I would suggest we sit with Mr. Review and figure it out. Not too many we want to argue, but we wanted to argue.
But I mean, I look at it this way. What is the number again, Mr. Odou?
1 through 14, so.
Well, I mean, if.
That's a big chunk.
Yeah, well, my point, that's a big chunk. My point is, hypothetically, if you want to argue to it, I mean, we can do that. Because that's a big chunk taken off, and that gives me more
I have a
administrative.
couple of these as being done already, but I think
Yeah, a couple of
maybe
them
we'll sit
resolved.
down, yeah, we'll go through the list and we'll see what's left.
Okay, sounds good.
And whatever you fine gentlemen agree with, I'll look at it, we'll do it. All right, and taking a look at the scheduling and the calendar, does it present a problem for anyone? Because we're fortunate, we do have Ramirez opening up, and we kind of crossed our fingers, but you never know. And it did so. Right? So I want to make sure we can take full advantage of all the time we have.
We're fine with this schedule, Tuesday through Friday next week, we're fine with your proposed schedule.
Your Honor, I have a question on the schedule for Friday. So Friday would be a full day?
Full day, right?
Yes.
Would we
Yes.
be able to possibly break at like 4 o'clock, something like that?
Oh, absolutely. I mean, I don't plan on keeping you here till 5, I don't think.
Thank you, Your Honor.
So we can, for the record, we'll make it Friday at 4 o'clock.
Thank you.
All right. So, Mr. Rasmussen, is that fine for you, sir?
It is, Your Honor, thank you.
Okay.
It was good.
Start at 9:15.
9:15, well, that's Tuesday.
On Friday. The start time for Tuesday, August 22nd, will be 11 a.m.
Okay.
Okay.
So we'll just go according to the calendar. I guess what she was saying was Friday, since we have the whole day, we'll go from 9:15 to 4. Right.
Your Honor, can we get specific times for Wednesday, Thursday, Friday? Start time.
For Wednesday, the 23rd, we'll do 1:15 p.m. And for the 24th.
Is that because that's a business work day?
Yes. And Lynn says afternoon only.
That's what she thinks. How, let me see, how bad is it? And this is one of the areas where judges can get a little bit overly optimistic about how quick, that's why when I have no problem when lawyers stipulate to move things around, because I understand, or when lawyers say, well, Judge, we're only gonna take 10 days, I know it's gonna take 15 to try the case. I just know based on history. And it's the same thing with us. I can anticipate we can be done by 10:30, and you know how that is, sir.
I've been there too many times, yes.
Too many times, and you're sitting around, it's 11:30, and you're saying, why did I come down here?
Are you busy?
Yeah, let me see. This
This
is,
is our business work day. This is Wednesday.
so how many contested matters?
8.
We have 8 it's 8 contested matters on Wednesday, so it'll be the afternoon.
Your Honor, on the 31st, can we do that till 4 o'clock, as I have to be at UCLA Medical the next morning?
Of course, sir.
Thank you.
Is that a Friday?
It's a Thursday.
Yeah, we'll do, so that Thursday and Friday will be 4 o'clock.
31st.
Your Honor, on this coming Friday, next, the 25th, can we begin at 10:30 rather than 9:15? I have a deposition at 7 that morning.
So we'll start at
10:30, I appreciate it, on the 25th.
And so the calendar involves 2 weeks.
Yes.
So the calendar covers 2 weeks, correct?
Yes, Your Honor. Your Honor, on the pretrial memo, my understanding is that might have been moved, the due date to the 30th, is that correct? I mean, we don't have a lot of motions yet.
Oh, as far as the due date of the pretrial memorandum?
Yes, Your Honor. Well, I misunderstood perhaps at some point. I was talking to Mr. Pepperman earlier. We're in agreement, our exhibits and so forth.
I mean,
we
if you
prematurely do this week if we had to go forward on schedule, so.
Well, do this week. And what have you and Mr. Pepperman agreed to?
Well, we didn't agree, he was just going to discuss with a group when we were all here. This was earlier before Mr.
We can have a
Rasmussen.
consensus right now.
Okay.
I'm fine with it. How's that? Mr. Pepperman, what's your recommendation, sir?
Well, Your Honor, I think it's a balance of what is convenient or workable with the court and the staff and us. We've made our pretrial disclosures. The exhibit lists are extensive and voluminous. Some of the court's rulings may benefit efficiency substantially, especially with respect to Real Water of Tennessee. But my understanding from Ms. Mercer's email was that the exhibits were due to the court by the 30th. I believe I may have misinterpreted the email and thought we could submit electronic exhibits by the 30th, but Mr. Odou informed me I may be wrong about that. Is that?
Electronic exhibits have to be reviewed and approved by the vault. So those have to be submitted as soon as you can, and the more exhibits, the more that they have to do, so they don't give a due date, but I wouldn't say any longer than next week, mid-next week.
So electronic exhibits could still be submitted by next week?
They can still be submitted, but if they get rejected, you'd have to resubmit them for approval again. That's why I'm saying
Okay.
as soon as possible, because there's an extensive process that they have to go through to make sure that they're.
Yeah, we appreciate that. We were looking at a mountain of binders and trying to logistically figure out how to get those to the court. If they're electronic, that cuts down the mountain quite a bit.
Yeah, if I'm getting hard copy exhibits, then they would need to be submitted by the 30th.
Yeah, and the problem would be if we had, I don't know how many binders, but we're looking at a lot. And so we're trying to figure out if plaintiff does theirs electronic and we join with a lot of theirs, that'll eliminate the duplication. And we would try to also do electronic, but it's just a matter of paring down all the duplicates at this point.
Is there an option to submit combined printed documents and electronic?
I think in a general sense, you're gonna have to have hard copies of the exhibits for the jury ultimately when it comes to deliberation, right?
Electronic exhibits get submitted to them on a laptop.
Yeah, but.
Well, here's
How
kind
do
of
you feel about that?
in terms of the way the lists are now.
I understand, but I mean, how do you feel about that laptop?
And the court does not provide a laptop.
You know, we did it with Judge Kishner in a large trial. I don't think either attorney was thrilled.
That's kind of my point. You know, I understand what they do, but if I was litigating, I don't know if I'd want that. You know?
I mean, there's going to be there's videos and things that we're going to have to use that procedure, and we've typically done in the past. But your Honor's point is well taken, that certainly we don't want to have all the exhibits on the laptop. I think practically speaking, what we see is there's a set of exhibits that we know we're going to use. It would benefit to print them out, and I don't think it would be an unreasonable burden to do so, to have the different sets. And then there are a lot of exhibits and a lot of voluminous pages that I think we need to have available, but it's far from certain that any substantial amount of them are going to be admitted. And so that's why I was proposing the possibility of submitting printed exhibits for the ones we know we're going to use and want to send back to the jury, and then having the voluminous other exhibits that are possibly going to be used in some extent. For example, medical records. I mean, there are significant medical records, and maybe a few of them are going to be used, if any, in all likelihood. So to handle those types of categories of exhibits in that way may be beneficial, and kind of slim down the amount of paper we have to copy and submit, and also slim down the number of electronic exhibits for the vault to after review.
Yeah, I personally prefer hard copy. And I believe that you could submit hard copy to me and then put them up, as long as they're admitted, obviously, for the jury to see. And then my hard copy admitted would go back with the jury. So if you didn't want to have to submit all these different copies for witness and whatever, because they have that monitor.
I mean, they do have, services available that will copy all these and help with pagination and the like. I understand the electronic. I think the reason why there's a preference from a clerk's office perspective, that makes storage much easier, right? Doesn't take up room in the vault and all, whatever it might be. But it's your case, and I would anticipate that regardless of whether you're the plaintiff or defendant, you'd want whatever exhibits readily accessible for the jury. That's what I would think, right? But versus, because for example, there could be something that becomes much more important during the course of the trial and it's electronic. What do you do with that? I don't know.
If you want, I can get with our people in the vault, and then get back to you this afternoon.
Yeah, if you could let
What
us
their
know.
procedures are.
Some of the judges didn't want both paper and electronic. They only wanted an election made as to one or the other. But if we can do a combination, typically the trial presenter brings a printer with them. And if something comes up during trial, we need page, whatever, and it's an exhibit that's been admitted, they can print it right off.
But here's my question, how many binders are we talking about?
Too many.
If, I couldn't even speculate, it would be a lot. I mean, right now, the combined exhibit list of
Maybe more than
everyone.
10, right?
Yeah, I mean, it might take up an entire room at this point.
Yeah.
But realistically, are we gonna use those? It's just a question of providing the exhibits that are on the exhibit list that may be used to the court. And so, like Mr. Odou suggested, I think the easiest way to do that would be a combination of hard copy and electronic copies of the exhibits. So for example, if, we all know which exhibits we're gonna definitely seek to admit or have been pre-admitted, all those would be in hard copies, exhibits, for example, 1 through 200. And then example 201 through 2000, or however long the list ends up being, would be submitted electronically. And if any portion of those exhibits are used at trial, then we would print them out and so they're in hard copy. But just until they're admitted or actually used, kept in electronic form just to save paper and space and be able to manage. I don't know, that's just kind of what
The way I look at it, it's your case. And so whatever agreement you come to is fine. I think it's important to remember that when you're dealing with the law, there's different issues, and I have no control over that. They do what they do down there, and I don't even know what they do. But when it comes to hard copies here, we're pretty flexible. And so you make the call, whatever format you agree to, I'm okay with.
We appreciate that, Your Honor. I just have one other question because this came up in the other trial. So the court is willing to take both electronic and paper, or the court wants all set paper?
I'm willing to do what would be most practical.
And we appreciate that. The other hiccup.
Right? That's how it should be.
Yes, and we definitely appreciate that. The other hiccup that we ran into in the other case was once the vault was set, once the exhibits were set, there was no ability to add to the electronic exhibits. The court said, no, that's it. You've picked your exhibits for trial. This is it. You can't do any other electronic exhibits. And if that's the rule, we'll live with it. But there were a couple of things that came up during trial where both sides agreed they wanted to get something in. And the court was like, well, you guys should have thought of that before you started trial. And it was a little tough going.
All right.
So if there is something that comes up,
I
it could be
look at
added
it
or not.
from this perspective, and I think, and I get it, one of the difficulties everyone has in cases like this, focuses on case management and also managing documents, and I understand that. And so I'm not gonna have any hard, like, for example, if at some point everyone agrees and says, look, Judge, we wanna add another 50,000 pages of electronic exhibits, and if there's no objection, I'm gonna let you do it.
Appreciate that, Your Honor. It was
I mean, that's probably the
a
best way
handful
to
of
say it.
documents.
Yeah, I mean,
Ran
yeah.
afoul.
Yeah, but and that's my point, though, if it was 50,000, I would let you do it if you agreed, it's your case. And my point is this, cases like this to prosecute and defend are complex, and you can't dot every I and every T. Things come up and things get overlooked. That doesn't mean you're a bad lawyer,
Thank you.
right?
Yeah.
Bringing up what Mr. Pepperman still up here as well, it's just deposition transcripts, and there have been a number of them used in this trial. Each one of us will probably want to submit those. If we did an original, plus we did one for ourselves and all that stuff, I don't see a need to do that if we just had one for the court, and that was all agreed to jointly for each one of the witnesses that we've got going on in this particular case. So every deposition, we submit a hard copy, sealed, ready to go, you have it.
And she can publish and you use it.
Right, exactly, as opposed to each one of us having to do ourselves do that, which is quite expensive and kills that many more trees, and there's no need for that. So if we
I
have
mean, do
one
we have an
joint
agreement
list.
to do that?
What?
If you have an agreement to do that, I have no
Are
problem.
we, I don't have a problem with that at all. If you guys wanna do it, if we wanna do it, you want us to share the costs on that, I'm good with that too.
One copy of each deposition?
Yeah.
Yes, we agree to that.
Yeah.
We can meet, confer, and
Yeah,
figure out.
because I want to do what's practical. I don't mind saying that. And that's often overlooked.
Yep, all right, thank you.
You're welcome.
And, I'll get with the clerk's supervision and the vault and give you guys a better answer.
Thank you so much.
Can I ask a clarifying question on the, Mr. Kemp mentioned he thought page lines on the depots were due Monday, and that's,
Yeah, we.
Is this the deposition designation?
4 days ago, we filed them. We've already filed them on Monday. We filed all ours. And I think you would have filed theirs too.
the page line designation. I mean, I had a 140-page disclosure on that. I know I disclosed the deposition of Brent Jones. I'm not sure if I have the page lines designated yet. Are we gonna have a hearing on those at a certain date then, or?
I mean,
Yeah, usually what we do is, when we get a little closer to trial, we provide the court a list of who we think the first video depositions are gonna be, and then the focal points on that, at least from the plaintiff's point of view.
Under the old schedule, I understood the page lines to be due the 24th, but I don't know what the clerk has. Your clerk has.
I mean, I don't have the.
They told me Monday, so I spent Saturday and Sunday doing page line.
So Monday.
It's the Raider game.
I can provide some clarification on this. So it was not 100% clear. The pretrial disclosure rule, 16.1A3, does provide that deposition designations are to be disclosed with pretrial disclosures, which is what we did on Monday, which is what UNFI did. A couple of the other defendants did it. We weren't sure because there is a scheduling order or a department order. I'm not exactly sure what it was that said the deposition designations were due 2 days before the calendar call, but we weren't sure if that was all the designations, because once we make our designations, they make their counter designations, they object to our designations, and we do our objections to their counter it's a whole little process. We weren't sure if that needed to be
We're
done.
not trying to jam anybody, Ron. We're not, saying he's late or something.
I think I only have two
But we thought
depositions.
that's what the rule required, so we did it.
So I guess,
We were worried about the timing, because like Mr. Pepperman just said, with all these counters, we didn't see how we could wait much longer than we waited.
I understand. So, sir, go ahead and get your designations right.
In terms of,
Does Rule 32 cover that issue too? you know?
Not scheduling, I don't believe.
Not scheduling.
Not on the deadlines or this process. And, you know, it's really a subject of the court convenience as well, because typically, you know, the depositions have to be, the designations have to be ruled upon and by your honor before we can play them. And that, in my experience, can sometimes be a time-consuming and arduous process. I would just state for the record that it's my hope that everyone makes their objections like they would be making in open court. Sometimes because you're looking at a piece of paper, there's an urge to object to everything that you normally would never object to, and I hope we can avoid that.
So we have, I'm looking here. We're starting on Tuesday, September 5th, correct? Does it make sense maybe to deal with objections maybe the afternoon of the 28th?
I don't have a problem with that, Your Honor. I would point out, though, that it's really the plaintiff's designations and the counter designations to those that are the most important at this point.
Right, I
That's
understand.
because that's going to come up first in the trial.
Yeah, I get it. From an efficiency perspective.
Yeah, so I'll ask.
And Mr. Kemp, how many designations do we anticipate from the plan?
I think we did 28, but out of that 28, we're serving subpoenas. I would guess that probably at least 10 of them are going to be live. So, I haven't tried to get a list together, but I could probably get a list to the court if the court wanted by, next Tuesday, say, what I think the first 10, we rulings on.
I'm thinking maybe we can schedule it in such a way. So you've made the designations already from the planner's perspective?
We've made ours, yeah.
And
We made ours.
We have new counters, right. I have not done my counters to those.
And Your Honor, since I'm a third-party defendant, I have UNFW as the third-party plaintiff. I'm countered to this, so not the plaintiff.
How about this, maybe set a deadline for counters and or objections within, say, the 23rd?
Okay.
If that makes sense, and then we deal with it the afternoon of the 28th, say 1:15?
Okay. Now I'm so sorry, Your Honor, just to make sure that I'm clarified on that, on August 28th, and really I'm asking maybe staff this as well, we will be starting at 9:15 a.m.
Yes. So in the afternoon, we deal with the deposition issues.
Okay, so in the morning.
And it might only take an hour or two, I don't know.
Judge, I think it's.
It might.
Well, we'll see.
It's
a half.
Maybe an hour per deposition.
So
Well,
9:15.
we have to start. Are you thinking we should start doing that exercise at 9:15 in the morning?
Judge, I think we ought to try to get the motion when these done, because we have a little flexibility here. We're trying to build a schedule so we can do the first couple days trial with live witnesses, just because we assumed that this would be a potential problem.
I think that once we get through the motions eliminated, I think that's gonna take us up through September 1st. Hopefully not, we'll see how it goes, but if it does take us up through there, considering how much time that we have, that then we might wanna consider going to these deposition designations at that time afterwards. As the court has made us aware, and I'm just following what you told us, and if I'm wrong in this, then the court should correct me. is that we have a September 5th trial date. That'll be our beginning to just get our jury selected. We don't anticipate things going on as far as, you know, opening arguments and things like that. We're still gonna have to get a lot of exhibits that's in here, so I really realistically see that it may take us until the following week for us to actually begin the plaintiff's opening.
All right, so you're thinking a week of jury selection?
Nope, taking jury selection, that's getting through some of these things having to do with depositions, making sure that all of our exhibits are squared away so that your staff, the vault, and everyone else is okay with that. That we have tried to organize ourselves in such a way that if they've got the exhibits that I need in theirs, I don't necessarily need to use mine number, that one can be just used once. Doesn't mean I won't have it on my exhibit list, but there's no sense in doing it 3 and 4 and 5 times. Because that's an efficiency thing that we should all try to do for this case. Fair enough?
I agree with Mr. Rasmussen, because remember, we don't start the jury selection until Tuesday, which is after the 3-day weekend.
Right.
So I'm thinking the jury selection is gonna take Tuesday, Wednesday, Thursday, maybe part of Friday.
Yeah.
And then the openings on Monday. That's
That's
just what I'm thinking.
It's gonna take longer than that.
Yeah.
It might take longer than that, yeah.
But it doesn't matter. I mean, I'm just saying. How about this? We can punt on that, and when you get closer, I will listen to your recommendation, and maybe we'll.
Just putting it out there then.
Yeah, okay.
Food for thought?
Yeah, and this is up to you to chew it up for me. How's that?
Understood, Your Honor.
Yeah, saying, look, Judge, you know, maybe tomorrow or the day after will be a good time to start working on those objections and or deposition designations.
Right. We have a deadline of the 23rd. We'll work with that.
Right, okay, so we'll just kind of leave those balls in the air. How's that?
Thank you.
Thank you, Your Honor.
Okay, well, in talking about that, we have to have some time set aside too for another purpose. And then we'll get back to the motions. But hardships.
Yes, Your Honor.
I'm glad you brought that up, because we've been, the people in the office doing that rag us every day. They would like some kind of day, you can, you know, maybe Tuesday afternoon would be a good time to do it.
I mean,
Thursday,
any time in the 2 weeks we can do it, but it's.
Well,
something-
I'm just thinking, these people, a lot of these people have given their hardship excuse weeks ago, right?
Right.
And so they're kind of sitting on edge and waiting to hear about it, so maybe Thursday afternoon we could do some hardships.
Is that the 24th?
What does the court mean by hardships, and what does Will Kemp mean by hardships? What do you
There are hardships that have been argued by the parties that there's disagreement about, whether they're a real hardship or not.
Okay.
And so what I'm talking about is the hardships that you're not agreeing to.
Okay, thank you. I'm sorry, I just needed that clarification.
Yeah.
Yeah, I would agree.
Because if you agree that there's a hardship, I'm gonna get involved.
They're gone. Yeah, and should be gone, right. And there's quite a number of those.
I'm not getting involved in that.
Exactly. You don't need to.
Right.
But there's
And maybe
several hundred that are not.
Friday morning, Friday afternoon.
Okay, we'll pick a time right now. And here's my point, and I feel very strongly about this, and I think this is often overlooked, but you know, Justice Roberts says we're here to call balls and strikes, right?
Yep.
But what if there's no pitch? There's no call to make, right? I mean, really, if there's no call to make and you guys agree, why would I get involved? That's my point.
Fair enough.
So Friday morning. for the-
Friday morning's fine.
Okay, that's-
That would be the September 1st is what you're talking about
We're
there?
talking about the 25th.
25th.
Oh, I like that.
Trying to inform
Yeah.
the world soon.
Well, see, that gives us enough time to contact the panel members after the decision's made. That's actually probably perfect, because that's approximately, what, 10 days or so before starting trial?
Right, and not only that, Your Honor, if they have 3-day weekend plans, they're not going to get you on the next election.
Exactly. You know,
All right.
so we're putting in right now in the calendar, we'll start on the 25th, will be all day, but the first, we'll start 9:15 that day.
Nope. We moved that.
10:30. Okay, 10:30 that day. And hopefully in the morning, we'll focus solely on potential hardships. Right, and of course, if you stipulated, we can read them off, we'll notify them, we'll let them go, we'll handle that first. But then we'll deal with hardships that, you know, it might be an issue.
Okay.
And to clarify, is it August 30th, the calendar call, pretrial, joint pretrial memorandum?
The calendar call is on the 24th,
It's still on the 24th.
yes.
The pretrial, joint pretrial?
As far as the calendar call is concerned, I don't see any need for everyone to appear at that, do you?
I don't, we're gonna be here in the afternoon. Calendar
Yeah.
call, I believe right now is scheduled for like 9 o'clock.
Yeah, there's no need to come.
There's no need, I think we can just do that and say, hi, we're all here in the afternoon.
I mean, the only thing, there's only one issue at that point. Have you settled? No. Okay. We're starting on the 5th.
Okay.
That's it. I mean, we know this case is going to trial unless a miracle.
So the joint pretrial memorandums do the
Right.
24th or the 30th?
That's right.
Yeah.
Your Honor, for clarification then, are we gonna be on Blue Jeans or no hearing at all?
Which day is that, sir?
The 24th for the calendar call.
Yeah, sorry.
No, there's no need to come. I mean, we're gonna be together all week. I know this case is going to trial. You got a firm trial date where you're starting on September 5th. At that point, I'm gonna bring in a jury and we're gonna start jury selection.
Would you
I
agree
guess we'll
with
just work it out.
calendar call?
Yeah, vacate their calendar. Wouldn't it be a complete waste of time?
Yes.
Yes.
Yes, okay.
And just for clarification, August the 22nd, we will actually be starting at 1:15 PM. And then August 23rd, same thing, 1:15 PM. August 24th, 1:15 PM. August 25th, 10:30 AM. August 23rd, August 28th, 9:15 AM. August 29th, either 10:30 or 11. August 30th, 1:15 PM. August 31st, 10:30 AM.
Thank you.
Is that? Thank you, Tori.
I'm sorry. August 29th is at 10:30,
The 29th can be the 10:30 or 11.
because it says afternoon only on our.
Yes, I'm getting, Lynn and Julian are listening in, and they're emailing me
Oh, okay.
updates of those.
See, they have a better feel on what's on my calendar. And so that tells me they think that's a light day.
So 10:30 is fine with Hanna Instruments.
Okay.
Was it Friday the 1st?
Okay, so we've dealt with depositions and designation. We're kind of kicking that can down the road. Then as far as hardships, we're gonna deal with those on Friday, August 25th at 10:30, right?
Right.
Okay, we'll deal with that. Then we do have the afternoon available. And, right, and it doesn't make sense to have a pre-trial calendar call. We're vacating that on August 24th at 10:30, because we know this case is going, and I'm gonna be seeing you every day anyway, so it makes sense to come down for that. And the time has been set aside. The only problematic issue would be for those cases trailing. They're not going on this stack, right? Because it's gonna take up the whole stack. Okay. Any other scheduling issues? Anything else, Matt, from your perspective? And we've taken care of the exhibit issues, you're gonna work on that together.
And I'm
Yes, Your
going
Honor.
to discuss with the clerk supervision in the vault as to any more detail.
Okay, and Tori will give you an update on that. All right, so is there one we can go to right now?
It's 10 minutes to noon, Your Honor. Do you want us to come back maybe at 1:15 again?
We could do 42 as a quickie, I think it's unopposed.
We have unopposed, let's do that.
Let's do that. It'll be fine. I was-
We had one to get something.
Which one did you say?
Motion to made number 11, it's number 42 on, this is our motion to include reference to the fact that epidemiologist Harry Hall was hired by plaintiffs. Dr. Hall was an expert in the Udosky cases, his Regulus firm hired him. We didn't hire him, but I was on the trial team, So we didn't think it would be fair if they would just say, oh, here's Mr. Kemp's epidemiologist. So I hope Mr. Robbins is on the line, because I think we agreed that they're not gonna do that. Also, I'm making clear, we're not interposing any challenges as to his qualifications to be an epidemiologist. I mean, we're arguing he shouldn't attend these for other reasons, but we're not saying Dr. Hall's not qualified to be an epidemiologist.
Mr. Robbins?
This is Rob Robbins, so with that understanding, then I'm in agreement.
Okay. All right, and so as far as that motion's concerned, which one is that again, Mr. Kemp?
That's a motion on number 11.
And
Plaintiff's motion on number 11.
and we'll grant it.
And then I think the next one, and as long as we're on a roll here, plaintiff's motion number 12, I think that's also unclosed there.
It's unopposed, yeah.
And for the record, that one is.
It's plaintiff's motion remain number 12 to preclude reference to real water bankruptcy agreement against the case.
We'll grant that. And is that it?
I think that takes us back to 20, Your Honor, which,
Next, we'll start after lunch.
yeah, we can do that.
So,
Okay, Your Honor, on 20, if I may, that is an opinion witness, Your Honor, that deals exclusively with punitive damages, so I think Hanna filed a parallel motion. Our suggestion would be that if the court is willing, that we kick that can down the road until after the motions for summary judgment on the same subject, and perhaps even after phase 1 of the trial, and take it up if it remains an issue.
You know, we're prepared to argue that one, and if Mr. Rasmussen wants to make his arguments related to his motion, I'm fine to argue both motions today. We're prepared, we just want to get as much done as we can. I don't see why we kick, at this point, I don't think we should kick any can down the road, in my opinion.
So I appreciate Mr. Parker's thoughts on this. Here's the situation. If punitive damages against Hanna Instruments, a distributor of an ORP meter, are denied by the court, then there's no reason to hear my motion to eliminate number 3, okay, which has to do with their CPA that's going to get up and say whatever he's going to say. I'm not going to try to telegraph that, but that's what's going on, and that's what's going on for UNFW. That's the same thing that's going to happen for Mr. Odou and his punitive damages motion as well. So some of these motions.
So as a predicate, which motion should we hear before that motion?
As a predicate, we should hear the motion for summary judgment on punitive damages first, and then we can get to whether or not the foundations have been set for the rest of what would be in UNFW's number 20 and my motion in eliminating number 3.
Mr. Parker, what about that?
Your Honor, I don't want to make a big deal of this.
And I think all they're saying is.
I understand what Mr. Rasmussen is saying, which I think is a little bit, what he just said is a little different than how this started. If they want to push the can based upon those other motions, then I said, let's get those other motions teed up and get them done as well. But we're prepared. We did this based upon the order filed, and that's how the court said they would handle it. No one objected to it until today, but I'll be flexible with Mr. Neale and with Mr. Rasmussen on the item. If we want to get those teed up first, then let's get those done as well.
You know,
What am I gonna say?
Yeah.
what do you want to do? It's really,
No,
I'm ready, I'm prepared to argue
This
anything.
is what I'm gonna do.
Yeah,
What's cracking? Right?
right.
And my point is this, and you're saying, look, Judge, hypothetically, depending on how you rule, those issues could become moot, right?
Yeah.
So I don't wanna, and whether it's 10% or 90%, doesn't matter. I don't wanna spend 40 minutes on something unless I have to. See where I'm going?
Right, and we have the same motion, so to speak,
Yeah.
about
So
the
let's
same
deal
person.
with the underlying motions first.
Okay,
And we don't have to do those today, but let's tee those up for,
I think
think I will.
Are they on today?
We're gonna do one today, Your Honor.
Okay, we'll do one today, but I was gonna say if we weren't, I was gonna make it a
If we're
priority for
ruling on
Monday.
one, we can go back to it today.
Okay,
That's fine with me.
all right,
That's fine,
Sounds
Your
good.
Honor. That makes sense.
All
Thank you.
right, just wanna make sure. Yes, ma'am.
So you said number 20, plaintiffs has a motion limiting number 20, and so does UNFW?
No, it's
So-
UNFW is number
UNFW
20. UNFW's number 20 was supposed to come up next.
The one next in line.
So we will reorganize somewhat and revisit it after the other one.
Thanks, Ted.
No,
I thought I had that conversation with you.
I'm sorry, it wasn't conveyed to me.
Maybe.
All right.
1:15.
All rise.
Thank you, Lynn. All rise. Court 60 is now in session on the Women's presiding. Please be seated.
Thank you. Let's go ahead and set forth our appearances.
Will Kemp, Theodore Parker, and Eric Pepperman, Plaintiffs.
Afternoon, Your Honor. Jim Neale and David Spurlock for UNFW.
Good afternoon, Your Honor. Joel Odou on behalf of the Rural Water entities.
Morning, Your Honor, Scott Rasmussen on behalf of Hanna Instruments.
Afternoon, Your Honor, Jim Kavanaugh, for Real Water Tennessee LLC.
Rob Robbins, Milwaukee Instruments.
All right. So I guess we move on, next up would be, is it UNFW's motion limiting number 20? Is that it?
That's the one, Your Honor, we had discussed deferring until after the motions for summary judgment on pleadings were.
Okay, so after that, we go to, what's next in line? Number 13?
Thank you, Your Honor. Eric Pepperman for plaintiffs. This is plaintiff's motion eliminating number 13 to preclude UNFI from arguing or inferring that violations of law or regulations are relevant to the compensatory or punitive liability of UNFI. So this motion has been, I think, a little further developed over the course of the last few weeks in arguing these other pretrial motions. Essentially, what UNFI wants to do is defend this case by arguing to the jury that they complied with certain federal regulations like 21 CFR 117.7. Grace,
And what is 117.7? I looked at the CFR, and I mean, because there's a short sight to it, we pulled the CFR up. It looks like to me that it deals specifically with unexposed packaged foods.
Yes, Your Honor. Chris, if you could pull up the regulation, please. First, there's substantial questions and confusion regarding the extent of how these regulations are implicated, even at all, in the strict liability claims and issues before this court and involved in this case. Certainly, there are federal requirements related to good manufacturing practices and procedures and hazard analyses in different contexts, but what we're talking about here is a distributor who is distributing a product for human consumption that was unreasonably dangerous, and strict liability claims related to that in terms of compensatory claims and punitive damages for the failure of UNFI to do even the most elementary take even the most elementary food safety precautions in the context of this case. So we're not implicating these regulations.
Sorry, one second, can we turn my, how do I turn my monitor on? I mean, it's on, but it's not tracking.
Oh, I understand, yeah. It's not.
It's not connected.
Yeah,
You got it?
I know, you're closer to it, we're able to do this one.
But I mean, it's on, but it's not tracking what's on the screen.
I can't really see what I can say. Should we call IT maybe? This is the first time we have that problem.
It's been like this a few.
Is it?
Yes.
All right, let me call them.
It's still, but go ahead, sir.
So, this is a very confusing issue that UNFI is seeking to interject into these proceedings, which is one of the main reasons why we brought this motion to begin with. So really, for our purposes, the provision that they're pointing to, it merely provides that certain federal requirements don't apply to a facility, to quote, a facility solely engaged in the storage of unexposed packaged food. Now, this regulation and others are on UNFI's exhibit list. So they put this on the exhibit list. They clearly intend to, try to act like the judge in this and hand this out to the jury, present it to the jury and make an argument that this is the law, that they're in compliance with it, they didn't breach it, and these types of legal arguments to the jury. And by this motion, that's exactly what plaintiffs seek to prohibit. This type of irrelevant, confusing, and misleading
I just want to make
argument.
sure I got the right CFR. Can you approach and show that the defense counsel, is that what we're talking about? Is that what's on the board?
It is, yeah.
That's the exemption, Your Honor. Yes, sir.
Yes, Your Honor, that's the one that's up on the screen, which basically provides, as I quoted, that certain requirements under this federal regulation don't apply to a facility solely engaged in the storage of unexposed packaged food. And so they want to, show this to the jury and argue, oh, we're a facility solely engaged in storing unexposed packaged food, and therefore we didn't have to do any of this stuff, and so our failure to do any type of hazard analyses or checks with respect to real water is somehow a defense in this case. And these regulations are irrelevant for that purpose. It's just a confusing argument to make, and it's a misleading argument to make, because this regulation has nothing to do with UNFI's compensatory or punitive liability in this case. First, UNFI's reasoning or thinking as to why it did or did not take certain food safety precautions with respect to real water involves principles of negligence. That is negligence, not strict liability. We've discussed the Trejo case extensively already.
You can just sit down.
Yes, Your Honor, they're on the way down.
That's okay.
Yes, Your Honor.
We discussed the Trejo case, which clearly prohibits injecting these types of negligence principles into strict liability cases. Allowing this type of federal regulation argument will only serve to confuse plaintiffs' strict liability claims with negligence considerations and risk misleading the jury and unduly prejudicing plaintiffs. Second, UNFI was not solely engaged in the storage of real water. UNFI was the purchasing agent for Whole Foods. Chris, could we pull up the distribution agreement, please? First page. So UNFI agreed by contract to be the purchasing agent for Whole Foods. UNFI is not just transporting products that Whole Foods buys. UNFI goes out and buys the products for Whole Foods based on lists provided by Whole Foods. UNFI is the buyer that contracts with suppliers like Real Water. And so what we put on the screen is the UNFI Whole Foods distribution agreement. You can see, Your Honor, at the top, this is the agreement for the distribution of products between Whole Foods and UNFI. And the base number of this first page is UNFI _0100000219. I'll just refer to the last three base numbers going forward.
What exhibit is that to
It's not, Your Honor. It's not mentioned in the brief or attached to any of these papers.
That's correct, Your Honor. It wasn't originally attached to the motion, but it's been produced as an exhibit in this case. We can submit a copy to Your Honor if that would be helpful.
Where am I able to find that?
We could submit a copy.
Well, we're again,
It's not attached to the motion.
it's not even part of the motion.
Well,
This entire argument is different than what was briefed.
as I mentioned, it has evolved a little bit when UNFI is up here in a prior motion saying that this statute provides federal preemption.
I mean, I don't mind seeing it, I'm looking at it, and that's why I was kind of surprised. I mean, I looked at the site, I'm trying to figure out how the statute has any application to this case. I know you explained it to me, but I'm trying to figure that out.
We'll go through it, Your Honor.
But go ahead.
Well, I'm interested in hearing the argument as well, because what we've heard in the prior context with these is that UNFI is claiming that this federal regulation that doesn't apply in this case at all somehow is a defense to the strict liability or punitive damages claims in this case. And I think given that argument raised in the arguments here, I think it's important just to show the court this agreement in which it is clearly contrary to that position. And it shows that UNFI is the buyer for Whole Foods. It's not solely engaged in the storage of unexposed food. If we turn to the next page, date stamp ending in 220. Under subparagraph B, you could blow that up, Chris. UNFI agrees to stock all the new products requested by Whole Foods after the effective date if a majority of the Whole Foods stores in the applicable region agree to purchase the new product. So what this is saying is Whole Foods tells UNFI to provide a list of the items they want UNFI to buy. UNFI goes and contracts with the purchaser and takes them, stores them, and
When you say
distributes it to Whole
UNFI, you
Foods.
mean UNFW? Just want to make sure I'm not missing anything.
Yes.
You're talking about W?
It's technically UNFI buys it, Your Honor,
Okay.
but they do store it in different regions.
But I think the court was saying UNFI is the same, we've been using it interchangeably with UNFW.
Is that correct?
We've been, yes.
It's not incorrect, Your Honor. The West, UNFW is the Western Division of
Okay.
UNFI.
We could go to the next page, date stamp
That's hard to
221.
do. Go ahead.
On 5, subsection B. Again, this paragraph provides, quote, UNFI will purchase and stock exclusives in inventory and for a period specified by Whole Foods Market. So again, this contract is providing that UNFI will purchase and stock the items requested by Whole Foods. UNFI is not solely engaged in storage, it is purchasing these products. If we can go to page base stamps ending in 230. Under 11, subsection A. Again, if a supplier or manufacturer is new to any west or east division of UNFI, UNFI will submit purchase orders to the supplier or manufacturer within redacted confidential of the date Whole Foods submits the new product request form. So again, Whole Foods requests something that they want to sell in their stores, and UNFI acts as the purchasing agent and goes and purchases the product and distributes it to Whole Foods under this agreement. Finally, if we could go to page 237. Subsection D. Product liability. UNFI acknowledges that it generally obtains indemnification agreements from the various manufacturers, suppliers, vendors, or distributors of products it purchases and sells. UNFI agrees to indemnify, defend, and hold harmless WFM, Whole Foods, and its parents and affiliates, together with their stockholders, etc., from any and all liabilities, including but not limited to personal injury, illness, or death of any person, arising from or pertaining to the handling, shipment, delivery, condition of consumption, or use of any product, without regard to any negligence by UNFI related to such product. This is the indemnification provision. So Whole Foods is contracting with UNFI. UNFI is agreeing to purchase the products for Whole Foods, and UNFI is undertaking the responsibility to ensure the safety of the product, and it's indemnifying Whole Foods for the same. Why is this important? It's important because Nevada law
Okay, we're fine. Just going to adjust my screen.
Nevada law has long recognized the obligations that exist when a company undertakes a responsibility like the situation we have between Whole Foods and UNFI here. And
Are you referring to a voluntary undertaking?
yes, I am. And the seminal case on that is the Dow Chemical case, the Mailhume. Malum. I always struggle with that. 114 Nevada 1468.
Your Honor, again, I'm sorry, Mr. Pepperman. None of this is in any of the briefing at all. It's completely different. These cases, the argument, everything.
It is beyond what was originally briefed, Your Honor, because this is what has been brought up that was never in the briefing before. There were federal preemption arguments raised by this court. That was never previously
Not
briefed or
raised by
made any
me,
motion.
but raised in front of me.
Raised in front of you, Your Honor, UNFI. And so they can't come up here and outside the briefs and say, oh, look at this statute, this gives us federal preemption, when they never made a motion for summary judgment. They never briefed that at all. They've never cited one case where this exemption regulation has been applied or absolved anyone of liability or been allowed to make an argument, yet that's what they intend to do. And so this is the motion. We cite this regulation as specifically precluding them from making this type of argument. And I do think it is important to point these issues out to the court, even though they never raised them early enough that would have allowed us to put it in the original briefing. They raised these issues after the briefing was completed. And again, this is the law. This isn't just some new issue that I'm manufacturing out of whole cloth. This is a seminal case that's been discussed in this case before, and it just is highlighting the simple reason why this is important. Because as you know, Your Honor, in the Dow's chemical case, until 1968, Dow Corning did not have a toxicology lab. They used the Dow Chemical Lab for toxicology testing and other information. In 1967, Dow Corning entered into a joint research and development agreement relating to the injection of silicone. And that case was about testing silicone for breast implants. And the issue in that case was whether Dow Chemical had undertaken the obligation to conduct the testing related to the testing and inspection of the safety of the liquid silicone. And we can pull up page 17 of the PDF. The paragraph, if you can blow up the paragraph next to 1494 on the right side. The record before us reveals substantial evidence from which the jury could determine that Dow Chemical undertook to render services to test the safety of the liquid silicone. It's just pointing out that when the evidence says that you undertook the duty, you can't come in and say it wasn't our responsibility. Just go to page 19 as well, Chris, please. Just blow up the paragraph on the right. It says based upon the aforementioned evidence. Again, based upon the aforementioned evidence, the jury could have found that Dow Chemical undertook to render testing services. That is exactly what we have here. UNFI undertook the role of purchasing agent or purchasing real water for Whole Foods. UNFI indemnified Whole Foods for injury caused by real water. UNFI, based on the agreement, effectively told Whole Foods, we are undertaking the responsibility to ensure safety and indemnifying you for it. This is on us, not on you. It now wants to take the exact opposite position at trial and tell the jury that wasn't our responsibility. Look, federal law says we have no responsibility to conduct even the most elementary food safety precautions, even though it took the obligation to perform them. It's like a game of hot potato with an invisible man. In this theory, they want to argue this federal regulation and say, well, we took responsibility for it, but it's not on us, we're exempt under inapplicable federal law. These arguments that these federal regulations, they don't apply. There's been no motions seeking to apply them. They want to print them out and give them to the jury as exhibits and make legal arguments as if these regulations are evidence. They have no application in the case. If these types of arguments are allowed, they will do nothing but confuse the issues, interject negligence considerations and strict liability claims, and mislead the jury into believing that federal regulators or the FDA has somehow approved UNFI's conduct or lack of conduct in this case. And for all those reasons, these types of arguments based on inapplicable federal regulations are confusing, misleading, and unduly prejudicial and should be precluded on that basis.